The future of progressive radio. This is the Dean Obadala Show on SiriusXM Progress 127.
And welcome back, Dean Obadala Show, live right here Tuesday, October 16th. Sitting in studio, replacing Rula Jabril, is our friend Danny Cevallos, attorney, MSNBC contributor, and man who does not adhere to a dress code because he's sitting in a T-shirt. And if you want to see him, he's on Facebook.com/DeanOfRadio or Twitter @Dean Obadala. Danny's dressed like we're in Goodfellas. It's like we're about to shoot a scene, and Danny's like, "Hey, everybody, how you doing?" Danny, how are you, my friend?
In fairness, Dean, I had a nice sweater on, but you keep this studio at a blazing 85 degrees.
No, I like to be cool in here, but we have, different issues with people. Let me ask you, Danny, we were just talking about Jamal Khashoggi and Donald Trump saying literally just a short time ago to the AP that Saudi is entitled to the presumption of innocence. He goes, here we go again, just like Brett Kavanaugh. He actually invoked Brett Kavanaugh. Look, am I missing something? They have video cameras of people going in and out. To me, it would be the shortest episode of CSI ever. The detective like, we got evidence of him going in. He ever come out? No, it's the Saudis. Roll credits. That's the end of the episode. From a criminal evidence point of view, what are you thinking?
This would be a very boring crime procedural because, and it just goes to show that in modern times, evidence in criminal cases is increasing exponentially because even in Turkey, we have 24-hour not surveillance video, but security camera footage showing that somebody went into a building and somebody apparently never came out, or at least there's no video footage of that person ever leaving. So in the criminal context as well as the civil context, we draw inferences. You don't necessarily need video, a smoking gun, or video of a smoking gun, but you can draw inferences like a person goes in, a bunch of people come into the country with expertise in dismembering bodies, and this guy never leaves the building. So, I mean, would it be enough in a civil standard of preponderance of the evidence? Probably, and probably without the actual video of the killing.
We just had Rula on, who's an expert on this, and said that from the papers and the sources that she gets from the Middle East, the Turkish government had bugged the embassy, which I'm sure we bug others' embassies, and they try to sweep, and then we try to rebug it. Well, they apparently had bugged the Saudi embassy in Turkey, and that's how they have audio of him being killed. And what she's saying now, the audio is him. They actually started cutting him to bits while he was still alive. And then one argument, though, the other one is that it's accidental death, which reminds me like in the mafia thing, like, hey, accidentally the guy, I was just shooting my gun into the sky there, and boom, he puts his head in front of it. It's not my fault. Or like, officer, he shot himself in the back 4 or 5 times. What am I going to do about this? I didn't do it. I just happened to shoot into the air, type of thing. And then accidentally cut him into parts and shipped his body back to Saudi. This is what happens. Boom. Let's go have some money got. Everybody.
Not knowing.
It's like a one-man show I'm doing there.
At least, I know, it's wonderful. No, I don't want to interrupt. I love it. I love it, Dean. You're one of the greats.
Thank you.
You're one of the greats.
My whole team's now Italian. Lauren and Matt. That's it. I'm half Italian. I'm going to the Italian side now. I'm giving up on the Arab side.
The problem is, Dean, if I jump in with my Marlon Brando impression, you're going to accuse me.
And you got the T-shirt from like Streetcar Named Desire.
Stella.
He's in character. Look at Danny. He's doing his scene. I didn't even know this.
I'm putting my nice sweater back on.
No. This is better.
An outrage.
Do your commitment to but do the whole thing. So the accidental death sounds like BS because they go from. First, the stories, the Saudi story, first public, this is not a guess, there's stories, he left the embassy. That we don't know what happened to him. Then they were confronted with evidence that there's no video of him leaving. And now the backup story, they might come out with is he accidentally died during interrogation involving a bone saw.
That's right. It's great to live in America where, interrogations can be a lot more like just sitting down with the Mueller team and talking with them in an informal conversation while they take notes or record it. In other countries, interrogation means something totally different. Now, as somebody who handles wrongful convictions, I know that often interrogations in the States can get a little violent, but not always. And we're talking about if somebody in the United States commits a killing by torture or abusing them, then it can still qualify as murder under most state statutes, especially if you're torturing the person. So it's amazing to me that we forget what a great country we live in because there are other countries where it can actually be an excuse that, well, we killed him, but we weren't trying to kill him. Just torture him. Just interrogate him or make him feel a lot of pain or waterboard him or whatever they thought they were doing.
What have you seen in different states? You were saying you've seen some violence. What are you talking about? Can you give us an example?
Well, just generally speaking,
Anything
I
with a
mean,
bone
there's
saw?
not. Well, you're not going to. I haven't personally seen a lot of bone saws in police interrogations, but I mean, in the United States, wrongful convictions result when police apply a little too much pressure in the interrogation process, and frankly, you don't always need physical violence to achieve a wrongful conviction. A lot of times it can be used. You can use pressure through the different read technique and other ways of interrogating people, which can induce a wrongful confession, even without laying a hand on them. So you could argue that the same violence is done when somebody's in prison for 20 years. But, on the whole, the United States is a much better place when it comes to civil rights. And certainly there's no police department in the country that would dream of saying, hey, the guy died in our custody, but listen, he was a little too sensitive when we started beating him.
But then again, we had a case like Freddie Gray, who was taken alive, put in the back of a police car, and comes out dead.
Okay, Dean, I have to push back on you comparing
No.
the potential story that the Saudi government...
No. I'm not comparing either one, but I'm saying people have died in custody. I'm sure in the time of Jim Crow, we saw that much more commonplace, where African Americans were taken to the police station alive and they came out dead. Well, so but Freddie Gray is a current one that jumped to my mind when you were talking about because of what happened in Baltimore.
Yeah, if nothing else, I mean, I don't... it's been a long time since we talked about Freddie Gray, but... one thing you can't dispute is that had the police never arrested him, put him in the van, and driven the way they drove, he would still be alive. And cuffed him, as I recall. Right. It's all coming back to me.
Right.
But you're right. I mean, that's another kind of, you could say, violence that's done to people who are detained when they're arrested. So,
I'm not comparing the two nations. I'm just making a point that there are some bad things. Let's go on another question, our speed round here of Stump Danny Cevallos.
Sure.
It's a new game we're playing, Stump Danny Cevallos. Win Danny Cevallos' money, like Ben Stein's money. No, there was a report, you may or may not have seen it. I hope you didn't, so now I can have an edge up here. But no, Michael Cohen talked to investigators for 50 hours. That's what they're reporting on MSNBC. 50 hours. I mean, seriously, it almost sounds like he was being interrogated. 50 hours, that's days when you add it all up.
Sure, it is. And I'll tell you this. Anytime the federal government, and by that I mean federal prosecutors, decide to cooperate a witness, it's not unusual in a very complicated case such as this for them to spend a lot of time with him. The reason for this is it's more than just getting his story or his multiple stories. They have to vet him. They have to get so much excruciating factual detail for a number of reasons. Number one, to make sure that the government needs to make sure that they're not being sold a false bill of goods, that they're not being lied to. And to decide ultimately, I mean, imagine the most meticulous car buyer. This is the ultimate kicking the tires. The government, if they want to use any information that flows from Michael Cohen, they have to make doubly, triply sure that it's valuable and that it's true and that it's credible. Mm-hmm. Because remember, I mean, this is a convicted criminal that they're getting this information from. And the government always has to contend with that anytime they cooperate a witness because they're essentially putting a criminal on the stand. So you can imagine they need to extra check the evidence in case it ever goes before a jury, because you better believe the first thing defense attorneys like me are going to bring up is the fact that the government has made a deal with a liar, with a criminal, with somebody who would do anything to get out of trouble.
When the prosecution is talking to someone who's a cooperating witness like Michael Cohen, and he says something, do they do almost a mock or real cross-examination to try to really press him to see where he's telling the truth and where he's lying?
Yes and no. They would probably do that closer to trial if they was actually testifying. They would prepare him for grand jury testimony or for trial testimony. But at this point, when I sat in on these proffer sessions, on these informal interviews, really they're just asking open-ended questions. They're, number one, trying to find out answers to their questions, but number two, they're also asking a lot of questions that they already know the answers to in order to
sort of
check
like I do
whether...
on this show.
Yeah,
I do the exact same thing to you every time on this show. Okay?
Well, sir, what you believe the answers to be is not always consistent with the truth.
I have it written down on my paper here. It must be true. Sorry.
So it may not be trial prep type testimony preparation at all. What it's more likely is a lot of open-ended questions and him bringing documents or describing documents or telling them where they can find the documents or giving them names of people, and then the government goes and checks out that name. I mean, it is a monumental amount of work. As a defense attorney, I've only sat in on these, but I've seen on my end the amount of work that they put into it. And they have to put in a lot of work because they know that they come to the table with people like this, with cooperating witnesses, already with the stench of having worked with a bad guy.
So I'm talking with Danny Cevallos, MSNBC lawyer. So let's take a break so we can reset and come back and talk about the decision yesterday in the Stormy Daniels defamation lawsuit, which led Donald Trump to call Stormy Daniels horseface on Twitter because he's a scumbag. But we will come back and talk about the legality part of what went on and why Trump was awarded legal fees in this case. And there's actually, if you like law stuff, it's kind of an interesting case because
it's
a
so
case
fascinating.
filed in New York ends up in California but applies Texas law. How does that happen? When we come back, Danny Cevallos is going to unravel all of it right here on the Dean Obeidallah Show. November 6, 2018 isn't just Election Day. It is Judgment Day for progressives and our vision of this country.
Don't go anywhere. This is the Dean Obeidallah Show on SiriusXM Progress 127. The biggest stories of the day. Right now. This is the Dean Obeidallah Show.
On SiriusXM Progress 127.
And welcome back. Dean Obeidallah Show. We're live right here Tuesday, October 16th. By the way, I won't be here tomorrow. Don't be concerned. I'll come back the next day. Tina Dupuy will be sitting in for me. I'm attending all day and part of this conference on countering violent extremism because I've had run-ins with white supremacists, and I'm part of this one-day thing here in New York, and we're going to play some of it after Election Day when things calm down. because it's a great learning experience. So I'm looking forward to it. So here, folks, if you're studying for the bar exam or you're a lawyer or you want to know something really inside the baseball park world, how's the analogy? Inside the football.
You're mixing your metaphors.
Kicking the football into the baseball.
Scoring
home run,
a goal unit.
Touchdown. Exactly. Choice of law. This is interesting. So Stormy Daniels sues Trump for defamation over a tweet. And we'll just talk about this procedural thing for a second. In New York, it moves to California, and then they apply a Texas law. Danny, explain what the hell went on.
Okay, so Stormy files in New York. The parties eventually agree to move the case to California. But California has to figure out, California immediately, because they're only acting as really a receptacle for this New York case. For all purposes, think of it as a New York federal case. So then, in deciding what state's law to apply, because that's a tricky issue. What state's law do you apply if you're suing someone like the president for something they said to their millions of followers on Twitter that went around the world in an instant? In our modern era, defamation is not the same as when I used to hammer a nail and posted an insulting thing in the town square about somebody. They're the choice of law. Those were the days. The choice of law issues there were very clear. Everyone was a resident of that state, and the town square is clearly in what state it's in. It's much more complicated when it comes to things like Twitter and social media. So the analysis reads like a very difficult law school question. But simply put, because this is a New York case, the California court applies New York law, but New York law as to decide what law to apply. There's a whole body of law called choice of law in each state, which, believe it or not, your state, wherever you are listening to this, has a section of its code called choice of law. And that's how the courts decide in complicated cases which state's law to apply. So just because the California court applied New York choice of law doesn't mean that they would ultimately apply New York law, because under New York law, you apply the place of domicile where the plaintiff lives. And because the plaintiff lived in Texas, and I think there's also a center of gravity test because it's where the damage occurs. And again, how do you say where the damage occurs with social media? Well, the analysis under the law is where the plaintiff lives because she's the one who's hurt. So now you have the strangest situation where you have a California federal court case which applied New York law, but only so far as it decided to apply Texas anti-SLAPP law, or in other words, the Texas
all right. We
CDPA.
don't go that far.
All right, I won't go that far.
This is like a who's on first thing. This
It
is.
is.
Like
It's very who's on first.
In any
what
event,
state's
folks,
on first?
And they were in federal court, by the way. So it was New York federal court, transferred to California, applied Texas law.
Right.
Now, what the facts of the lawsuit simply are: Stormy Daniels sued Donald Trump with Michael Avenatti as the lawyer for defamation over a tweet, and it had to do with her interview last year about that someone threatened her. Yeah. Or earlier this year, actually, April 2018. Go ahead. You want to tell us a little bit about it? Or you want me to
defamation is basically a false statement made about the plaintiff that causes them damage, and the person making the statement, the defendant, had to act with malice or in other words, willful blindness, I guess I like to call it, of the fact that it was false. In other words, they either knew it was false, or more commonly, they acted in reckless disregard of facts showing that it was indeed false. They basically saw no evil, heard no evil, and said it anyway. And that's basically defamation. Now, the court entered into a very interesting analysis, concluding that because what President Trump...
we should tell people to tweet this. Hang on.
Oh, yeah, let's do the tweet.
Donald Trump... Stephanie Clifford, who is Stormy Daniels, does the interview, says she got threatened by some guy, and there was then the artist rendition of this guy comes out. People might remember earlier in the year. And then Trump gets his artist rendition and tweets out a sketch years later about a non-existent man, a total con job, playing the fake news media for fools, but they know it, ! Because he's stupid. And so they sue for defamation, saying you're calling me a liar about me being threatened. And that's the whole lawsuit based on this one tweet.
That's right.
Go.
So the court walks through the analysis of defamation, and it starts, and it's very important to say it walks right through the elements. And I say that it's important because the court never decided some of the later elements, which might have been another battleground as well. But the court ends its analysis early on by concluding that what President Trump said wasn't defamatory. If anything, it was protected, and it was part of the constitutionally protected speech, what you would call rhetorical hyperbole.
Rhetorical hyperbole, everyone.
Right. It's basically just exaggeration, fiery exaggeration.
And the First Amendment protects this type of rhetorical statements, is the court order right here.
That's right. So, President Trump is really, sometimes he either accidentally or seems to know what he's doing, because he uses the word con job, which I think is very open to interpretation. Had he called someone an outright thief, for example, or called somebody...
Look, what if he had
something
tweeted, Stormy Daniels is a liar, she knows she's lying, this is absolutely crazy or ridiculous, and she should be...
See, you said very interesting things there. In your first breath, you said liar.
Right.
That
Opinion.
is closer to... No, it's closer to actionable.
Right, that's what I was trying to get at. As opposed to rhetorical hyperbole. I'm trying to give people an example of what could you think she could have sued Trump for in a tweet that would have been actually defamation that she, at least on its face, be actionable.
Right. So calling someone a liar, not always, but in this context, it might have been actionable. The thing about defamation is that no statement is really truly alike, because context changes every statement. Generally speaking, if you accuse somebody of a crime, that will bring you into the category of what we call defamation per se. Accusing someone of a crime or saying they have a loathsome disease is part of the narrow category of defamation that will be actionable, that will be the plaintiff can win even if they don't have any damages. That's not the situation here. It's actually on the other end of the spectrum. What President Trump said was so middle of the road, according to the court. It was just hyperbole. You are allowed to do some fiery exaggeration in your speech. And so you can say, hey, so-and-so is ridiculous. That isn't necessarily accusing anybody of a crime, especially when you look at the context.
So if he said Dean stole something, if Trump tweeted, Dean Obeidallah stole $10,000 from me, and if I did not steal that money, let's say, for argument's sake, say I didn't steal it.
For argument's sake, when we know what really happens on a daily basis.
I didn't steal it, but if it was that kind of statement of fact, that's defamatory. That's actionable.
Definitely. I mean, that statement would be more actionable than instead saying Dean Obeidallah is dishonest. Right. And or even less actionable would be make sure you check your wallet when Dean Obeidallah leaves the room, because that requires some inferences.
Actually, that's something
I tweeted it. That's where you've heard it.
That's usually one of the things that I hear a lot when I'm walking out of rooms.
That's right.
All right, so this happened. So you've got rhetorical hyperbole, because, folks, it's got to be not opinion. It's got to be a statement of fact, but also this intersects public concern. So, concern.
I'll give you an example of what I mean by that.
There's so much going on.
Right. So, defamation can be a very complicated analysis, because after all this analysis, it really just comes down to every single statement is different, and you're going to get a different analysis depending on what court looks at it. So it's hard to create analogies to prior statements in prior cases. In this situation, not only was this considered rhetorical hyperbole, but it was additionally about what's called a public concern. In other words, it is more protected if I say the mayor is a real con artist versus Steve or my Aunt Edna is a real con artist, because in the political context, a lot more leeway is given a speaker. And the idea behind that is that once you start speaking about matters of public concern, like your leaders or your politicians, you're getting into the area of really constitutionally protected speech. The right to how does it go? People to redress their grievances or whatever it is in the First Amendment. You know, that Constitution thing.
Sure.
And so once you get into that area, it's going to be much more protected than if you just defame or say something nasty about a private citizen.
But the Aunt Edna thing causes problems at Thanksgiving, though. That's a big... If you call Aunt Edna a con person...
Oh, we are fast approaching Thanksgiving, the most defamatory time of the year, where everybody gets around the dinner table. Some college sophomore spouts out all the things they learned from Dean Obeidallah in Dean Obeidallah's textbook, left, lefty, left.
All right, so your mocking tone towards progressive values is disgusting. So, last thing here, Donald Trump is so happy today. In fact, he called her Stormy Daniels horseface, and then was happy about getting the legal fees. Most people understand in the normal case, you don't get legal fees. You file a lawsuit,
That's right.
Someone defends it. Both sides have to carry their own costs unless there's a statute or some other principle involved. What happened in this case that Donald Trump was awarded legal fees?
Now, in a strategic, I would say, disadvantage, Michael Avenatti and the plaintiff in this case wandered into Texas what we call anti-SLAPP law, which happens to be some of the strongest anti-SLAPP legislation in the country. And I'll explain anti-SLAPP. It's strategic lawsuits against public participation. It's actually a law in many different states that allows somebody who's sued for what they believe to be expressing their constitutionally protected right to speak. It allows them to turn the tables on a plaintiff and make them prove to a court, hey, this is a legitimate defamation case. This is a legitimate lawsuit. We have a prima facie case. This is not just us a big corporation trying to silence a little plaintiff who left a review on Yelp, or somebody who went to a zoning board hearing and complained or raised an issue. This is a real legitimate defamation case, but the court's going to make them prove it. That's exactly what happened here. The only real traditional change is that the roles were reversed. In this case, the defendant was the big company, the Trump side, and the plaintiff was the David to the Goliath, was Stormy Daniels and Michael Avenatti. Now, basically what Trump argued was he said, hey, they're basically, all the facts, we'll assume they're true for the moment, and this is essentially a lawsuit that just they can't win, even if everything they say is true, because I have a constitutional right to say what I said. And the way anti-SLAPP lawsuits work is that if the defendant wins in throwing out that case, especially under Texas law, then that particular statute allows for attorney's fees. What those are ultimately is surely subject to a reasonableness test by the court, but it's one of those rare instances where the normal American rule, there's a departure, because traditionally in the American system, both parties bear their own costs, unless there's a statute providing for attorney's fees.
And this will all be on the final exam, folks, in case you're wondering about that. That's a big test. All right, let's take a break. When we come back, I answer the question. Donald Trump had made a promise. We'll play the clip. To pay $1 million to a charity if Elizabeth Warren took a DNA test and was proven to have Native American ancestry. And that happened. And now the question is, does Donald Trump owe $1 million to some charity of Elizabeth Warren's choosing or any choosing? We'll take a break. We'll have Danny Cevallos break that down for us right after this break on the Dean Obadala Show. Every day between now and Election Day, ask yourself, what am I doing to help the resistance win? The stakes are so high, we cannot take off a single day.
The Dean Obadala Show. Welcome to the Dean Obadala Show on Sirius XM Progress 127.
And welcome back, Dean Obadala Show, live here Tuesday, October 16th, in the studio with Danny Cevallos, MSNBC legal guru. Danny, I got a question here about obligations to pay. Here, let's play Colbert setting up a little of the clip of how Donald Trump promised to pay Elizabeth Warren, not her, a charity, $1 million. Let's see clip number one.
You cared so much. You once offered $1 million to charity if Senator Warren proved she was part Native American, a fact reporters reminded you of today.
Mr. President, you said you
Who cares?
$1 million to charity.
I didn't say that. I think you better read it again.
Oh, we don't have to read it. Luckily enough, we're going to have somebody read it for us.
Let's say I'm debating Pocahontas, right? I promise you I'll do this. I will take, those little kits they sell on television for $2? Learn your heritage. We will take that little kit and say, but we have to do it gently. Because we're in the Me Too generation, so we have to be very gentle.
Okay, I'm going to stop right there just to point out that Trump went out of his way to stuff a Me Too joke into the middle of his racist tirade. It's like he's making a turducken. That's just all turd.
So, all right, so you
Great.
heard Trump there, and he said, take the test, and if you take the test, I'll give you $1 million to charity if it comes back Native American. I'm getting the sense there are a lot of conditions on that offer he made. Well, by the way, could somebody let me ask you in general, could somebody make an offer publicly that someone else can act on, and then they have to pay them on it?
Absolutely. That's what a reward is. That's exact. I mean, it's called a unilateral contract in contract law, and normally a contract requires an offer, an acceptance, and the performance or the consideration on both sides. Each side has to give something up. That's why a gift is not enforceable until and unless it's in your hot little hands. But there is an exception. For example, if I put up a sign that says the first person to mow my lawn gets $10. Or any kind of contest is
right.
often a unilateral contract. So normally you accept a unilateral contract, you accept by performing, not by saying I accept. In most contract cases, there's some tacit acceptance. But in the case of a unilateral contract like that, where you say, I will give $1 million to charity if somebody does something, then that person accepts and the contract becomes enforceable upon the commencement of performance, or in this case, it would be the completion of the test coming back positive in a way that shows that she has Native American heritage. But it's a very interesting and wonky area of contract law, but one that also affects all of our lives. We all deal in unilateral contracts all the time.
So, all right. So in general, you can. So if someone said publicly, if this person's very specific, the offer is made to somebody, in this case, if you, Elizabeth Warren, take this test and it comes back in a certain way that fulfills the conditions, and I'm going to give $1 million to charity.
Yes.
Now, his argument, and I heard him today, I'm sure his lawyer said something to him like, the condition was she's got to be in a debate with you and you're going to give her, does that work as a defense to this?
Sure, it does, because you have to look closely at the invitation, or what do they call it in unilateral contracts? Essentially, it's the open. I guess it's an open offer. You have to look at the language of the offer. Did she satisfy all of the conditions of performance, even though she didn't have to openly say "I accept"? That's the interesting thing.
But then
about
later
unilateral
she tweeted
contract.
afterwards, reminding him.
Right.
Elizabeth Warren tweeted, by the way, Donald Trump, remember saying on July 5th that you'd give $1 million to charity of my choice if my DNA showed Native American ancestry? I remember, and here's the verdict. Please send the checks to the National Indigenous Women's Resource Center.
Right.
So there she is, like, it's a dead or alive poster.
Right.
Went out there, got the person, boom, pay up.
Right. No, I mean, her argument is that this was a unilateral contract. I accepted, and the contract was completed when I performed, and when I performed, it was when my DNA came up with Native American heritage. One out, as I've been sitting here thinking about it, could be, is this a unilateral contract, or is this a form of unlawful gambling? right? Because
Tell me.
I'll tell you why.
Because
the difference between gambling and a unilateral contract is that gambling leaves something to chance. And if you're betting on the outcome of a DNA test, I would say that there's nobody who could accurately predict. Well, no, that's not correct. I would say that nobody could predict their percentages. But in this case, Trump was just saying any Native American heritage. It's possible, and you hear this story a lot now with people taking these tests, that they took the test and it came back something that totally surprised them.
Right.
So, for example, I came back 5% Jewish when I took it, and I had no idea there was any Jewish ancestry in my background. But if somebody had said to me beforehand, I bet you come back Jewish heritage, that would have been a game of chance in my mind.
I would have guessed that because you bring up the Torah many times on this show.
Yes, and I am almost fluent in Yiddish because I find Yiddish to be the most perfectly descriptive language in the world.
Do you understand Yiddish?
Well, I know a lot of Yiddish words, but they all work. I mean, they all sound like what they describe. It's the most perfect description.
Everyone wants to know an example.
Oh, we're going to go get a schwitz. Schwitz means sweat. That sounds like what sweating is.
Well, it's like bubala. Isn't that like...
Isn't that grandmother? I think that's something like that. It's adorable. It's a great word for grandmother. It's better than grandmother. Grandmother is very boring.
Interesting.
Yeah. Listen, I've got a lot of answers here.
Well, Arabic habibi is nice for like a friend, or habibti for a woman.
Shukran, afwan.
Oh, thank you.
Yalabina. Yeah, yalabina in Egyptian is let's go. Yalla is just let's go in Arabic. Oh, I love Arabic.
All right, so Danny.
Let's talk about horse faces.
No. All right, let's take Michael from the Bronx. Email saying he's got a question for Danny. We'll see if Michael is still there, because not often somebody emails me and says, I have a question for Danny when Danny comes on and Danny's here and Michael's waiting. Let's see. Michael, are you there?
Hey, can you hear me all right?
I can hear you fine. Can you hear us?
I can hear you
This is
good.
a hearing test. It's not even a radio show. Michael, you can't ask two questions. I saw in your email, Michael had various questions, follow-ups. One question. Ask the one about Stormy, because we were just talking about Stormy Daniels, if you don't mind.
Oh, God, now you're going to make me curse on the air.
No, you don't have to curse. What was it? The other one was about election law. I'm not sure if you know much about that, to be honest. It's not an area.
About the Brian Kemp thing.
Right, Brian Kemp in
Right,
Georgia.
that one I'll have to make up because I'm not well versed in that one. Let's
Right,
talk
so-
Stormy, Michael.
Yeah,
Come
talk
on,
about the defamation
listen.
claim.
I'm very
Stormy.
excited you're on the phone, Michael. Let's go. I'm excited.
Great to meet you, Danny. All right, the thing is that with this bogus ruling from this judge, I suspect
Your phone is Michael.
Michael,
What's wrong with the phone, buddy?
You've been on hold for 2 hours and you're talking from a Vietnam era walkie-talkie.
Go ahead.
Can you hear me?
I can, but Garbo, go ahead. Hopefully this is better.
All right, the question is that I suspect that this judge was a Trump-appointed judge, because I can't understand such a ruling. But then when Trump called Stormy Daniels horse face, would that give Stormy the right to respond and calling him horse shit?
I don't know
Sure.
about that, but what about, I thought you were going to ask a legal question, not like she can say anything.
Michael, I would actually say, really, you could make an argument, and I'm just throwing this out there. This is kind of a glib response, but calling Stormy horseface arguably could be more actionable than the total con job.
Why?
Because it's directly disparaging to Stormy Daniels.
Sure.
When Donald Trump said a total con job, I think that left open whether he was calling her particularly a con artist or a criminal or a liar. And I think that's exactly what the court honed in on. Not only that, but the fact that he was engaging in protected speech against what the court deemed a political adversary. I think that could go either way. But I mean, the court was pointing out that, listen, she's taking him on in the public eye, in the public arena. And because of that, anyone's allowed a little leeway in the political context to use a little what they call rhetorical hyperbole.
And nothing regarding the fact that she was threatened in a parking lot by somebody that happens to be a Trump ally or a Trump fan.
Well, we don't know. We just don't know that part.
Right. Now, you bring up a very good point, Michael, because Stormy Daniels' argument was that the reason Trump knew what he said was false was because he knew that there was a guy who threatened her, because he sent the guy who threatened her. Or in the alternative, he didn't know one way or another, therefore he can't say whether or not she's a liar. Now, those are two very inconsistent positions, but the point is this. If it was uncontrovertible fact, if it was a known fact that she was in fact threatened and Donald Trump sent the guy who threatened her, then we'd probably be having a different conversation. Because then,
and the thing is,
go ahead.
The thing is that we cannot actually say for sure if Trump sent that guy there, although we have high suspicions. But I wouldn't dismiss it, given Trump's inciting the violence and rhetoric towards his base. If
Judge
someone
Michael
took the
has ruled.
initiative.
Judge Michael's Michael.
I would say this, Michael. Michael, do we know? Is it known that Stormy Daniels was in fact threatened?
Is it known? I would say yes.
Okay. Well, then to do so, we have to rely only on her account. That means that you either adopt or don't adopt it.
But a testimony is evidence. I mean, this game of how there's no evidence to support Dr. Christine Ford. Well, she testified under oath. That's evidence, folks. I mean, that is evidence. You can undermine that evidence. You can question the credibility of the person giving you that, proffering that evidence. Right. But it is by its very definition, it is evidence. So that's why on the right, like, there was no evidence. Dr. Christine Ford was. That's my impression of Kendall, by the way. If he's listening, there's no evidence. No.
And Dean,
let me ask you this then. So let's say Michael and Dean.
Yes, Michael.
Go ahead.
Then we're gonna let you go, Michael.
For the record, I'm glad you brought that up about Dr. Christine Ford, because from what I've observed, the way this went down, it seems like not only did Brett Kavanaugh get off the hook, but the same thing with Mark Judge. They were both said to be inside that room.
I agree. All right, Michael, thank you for your question, though, my friend. I appreciate it. And Danny, it's nice to meet Danny because he's mentioned you a few times on the show. So it's good that you finally connect. All right, thanks, Michael. No, but get into this. I mean, you have people on the right saying Dr. Christine Ford didn't show any evidence, and you need evidence. And when someone like Christine Ford, me saying something to you is evidentiary, right? It's evidence of something. But when you testify under oath, like she did, and it wasn't a court of law, but in the potential penalty of perjury, it's clear that was evidence.
No, I would never dispute that. But what I would say is that it lacks corroboration.
That's different.
Corroboration is a different concept. But yes, you're absolutely right. Somebody raises their hand and gives testimony. That is evidence. And Dr. Ford was different because, like you said, she did that under oath. Stormy Daniels, as far as I know, has not testified under oath that she was threatened. But more importantly than that is she hasn't adduced any evidence that Trump knew about it or sent that guy. So she may have said that, hey, I was approached and attacked, but I don't think she has any evidence showing that it was Trump's guy or that Trump sent the guy.
If she did, that would be different because
I don't know. Maybe they do and we haven't seen it yet.
Your experience, you're a criminal defense attorney. I'm chatting with Danny Cevallos, MSNBC legal expert and criminal defense attorney. If you had simply what we saw with Brett Kavanaugh, just to give people an example, not Brett Kavanaugh specifically, but in general, you have Dr. Christine Ford testifies that I was sexually assaulted by that man. There's no statute of limitations in Maryland, so they could happen today.
Okay.
So just say this is a normal case, but it happened years and years ago.
30 plus.
30 years ago.
Right.
She testifies. Then if she goes to the police and says that, it's their the prosecutorial discretion about whether he's going to bring charges or not based on...
In a way, it starts even earlier than that. It starts with the sex crimes detectives who... often, I mean, they have to decide whether or not someone's even credible enough to even present a case to the prosecutor.
But say you get it to the point where...
You're asking me whether Christine Ford, based on what she testified to, whether that is something that an
objective prosecutor
would have brought.
Do you think they would have said, let's pursue this?
Respectfully, and I don't want to disparage anyone involved in the ordeal.
Reason why. I know where you're going with your
And I'm sure it was
why?
A very difficult ordeal, but using the burden, every prosecutor and every detective hopefully has the high burden of proof in their mind when they're investigating a case of beyond a reasonable doubt. And I do not think any prosecutor or any detective would have thought that this is a case from 30 years ago that they could win. I think they would have even thought that the jurors would have thought, why are we hearing this case 30 years later? Even though I understand, I'm not discounting the fact that victims do not report, and sometimes they only remember many years later. However, that coupled with the fact that a defense attorney, and I'm just putting my defense attorney hat on now, that the actual conduct complained of could really be challenged by a defense attorney. This is not, I mean, I believe, and excuse me if I'm wrong, but I believe her testimony was that he was grabbing at her clothes, maybe trying to pull her swimsuit aside. I hate to get detailed like this, but I don't think she ever testified as to any specific contact with her breasts, her breast parts, or her private
Because
private
no one was
parts.
asking her that, like a prosecutor probably would have asked those
Exactly.
questions.
And I think that's very significant because from a sex crimes perspective, if you don't have somebody who can come in there and say, hey, and I hate to be, describe the parts of the breast that were touched in a sexual manner, as opposed to somebody fumbling at clothing or grabbing at clothing. And if that's the very best that she can do, I'm just not sure, even if there is no statute of limitations, that a prosecutor would have brought this case. I just don't, and that's just my personal take.
So let me ask you, if a woman today comes forward and says, yesterday, and I guess the difference is, if something happened yesterday, now we have DNA tests. We have a lot more goes on, right? But someone said,
so this wouldn't have been a DNA test,
right,
in any sense.
So someone comes forward today and does what Dr. Christine Ford, goes on the stand. It didn't happen 30 years ago. It happened 6 months ago. I have no corroborating witness. Would there be enough there on that testimony? And assuming the prosecutor asked any more specific questions you're getting at.
Right.
On one person's word alone, that's really my question. Can you convict someone beyond a reasonable doubt?
Yeah, you can convict. Many assault and sexual assault cases involve one witness who is the complainant, who is the victim. So, yes, you can convict people without corroboration. That is a really good development in the law over the past many decades. However, it is obviously, any prosecutor would be lying if they said that it's not hard to do so. It's easier to do so if you have a witness or some corroborating evidence. And that might be something like a ripped shirt, or obviously a rape kit, or even without a DNA test, something showing that this person was the victim of something violent. But go back to the allegations in this case, was that he, and I'm not minimizing it, but
I wanted to know in general for people,
right,
not about her. But even with DNA, like if you said someone grabbed my arm, can they find with DNA testing that there's DNA of that person on my arm? Right,
but as a defense attorney, I would argue there are many different explanations for why there might be DNA on someone's arm. I mean, you might just have inadvertent contact. The theory of transference, what you find in cases with gunshot residue and other things, is that almost everything around us, I hate to say it living in New York because it's very gross to think about, is particulate. So that even though you and I may have shaken hands, you may have touched your hands and then put it on your forearm. And the theory of transference is that with diminishing amounts, you can continue to transfer in diminishing amounts with each touch. So that the reality is, and more in wrongful conviction cases, we're finding that transference accounts for a lot of wrongful convictions because you show that somebody's DNA is somewhere and they may have been 2 degrees removed from that place. So just because somebody put their hand on your arm, not necessarily or that the DNA is on you, doesn't necessarily mean you done it.
Let's take a quick break. Come right back with more of the Dean Obadala Show.
Dean Obadala Show on Sirius XM Progress 127. The Dean Obadala Show on Sirius XM Progress 127.
And welcome back. Dean Obadala Show. We're live right here with Danny Cevallos. I promised Danny we're going to play this quick clip. This is Trevor Noah last night on Daily Show talking about Donald Trump owing Liz Warren $1 million and how Liz Warren should try to get that money from him. Here's clip number 2.
If I were Elizabeth Warren and I did end up in a nomination, like if I was the nominee for the Democrats and I was debating Donald Trump, you know when they do the walkout music at the debates, they go, please welcome Donald Trump, and it's like, and you walk out to that boring music. If I was Elizabeth Warren, I would make sure that when I walk out, it's like, and please welcome the Democratic nominee, Elizabeth Warren, and be like, bitch, better have my money. Now, see now by JJ, pay me what you owe me. Don't act like you forgot.
So, would that be effective, Danny? Danny looks dismissive, like a dad. It's like, he was quoting a song.
I don't know what all these kids are talking about, this music. Now,
Danny, we have 1 minute left. What are you going to tell us today?
Okay. Well, listen, with the time we have left, if you don't mind, I would like to count to 1,000. 1, 2, 3. Wait, I'm just getting to the good part.
All right.
It's 4 and 5.
I want to thank you, Danny, for being here. I'm on Twitter at Dean Obadala, Facebook.com/Dean of Radio. I'm not here tomorrow. I'll be at a conference. I'll tell you all about it Thursday. But Tina Dupuis will be in tomorrow for me live. Then we'll be back Thursday fighting the good fight, my friends. We're going to have Rory Kennedy on, Bobby Kennedy's daughter, about her documentary about climate change, about NASA. It's really about climate change on Thursday. And Riz Ahmed, Emmy Award-winning actor from The Night Of. We'll be back with more of the Dean Obadala Show. Not tonight, tomorrow, folks. Thanks for tuning in. Talk to you soon.